This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why a non-signatory to an arbitration agreement cannot compel arbitration. In a case called Alex Weingarten versus certain underwriters at Lloyd's, the California Court of Appeal on March 23, 2023, decided that the underwriters who had appealed the trial court's order denying their motion to compel arbitration of plaintiff Alex Weingarten's complaint for breach of the implied covenant of good faith and fair dealing, intentional infliction of emotional distress, and negligent misrepresentation. In 2013, Levin, Tristen Lazareff, and Criterion Capital Partners LLC retained Weingarten Brown LLP to defend them in a case entitled MXB versus Levin. The retainer agreement contained an arbitration provision. Levin and Criterion Capital Partners filed an action in the Los Angeles Superior Court for legal malpractice and breach of fiduciary duty against Weingarten et al. The complaint alleged Weingarten negligently represented the defendants in the MXB action. The parties later stipulated to arbitration before JAMS, the Judicial Arbitration and Mediation Service, based on the arbitration provision in the retainer agreement. Weingarten notified Lloyd's underwriters about the malpractice action, and Lloyd's underwriters accepted the defense of the Weingarten defendants. The arbitrator found in favor of Levin and Criterion Capital Partners LLC and issued an award that exceeded Weingarten's insurance coverage. Weingarten sued Lloyd's for breach of the implied covenant of good faith and fair dealing, and in the operative complaint, Weingarten alleged Lloyd's underwriters acted in bad faith in the malpractice action by, among other things, rejecting settlement within policy limits. On January 31, 2022, Lloyd's underwriters filed a motion to compel arbitration of the complaint based on the arbitration provision in the Levin-Weingarten retainer agreement. Weingarten opposed the motion, arguing, logically, that the insurance policy issued by Lloyd's underwriters did not contain an arbitration provision. Lloyd's underwriters were not intended or a third-party beneficiary to the Levin-Weingarten retainer agreement, and the doctrine of equitable estoppel was inapplicable. After a hearing on the motion to compel arbitration, the trial court denied the motion. Lloyd's underwriters contended that the trial court erred by denying their motion to compel arbitration based on the arbitration clause in the Weingarten-Levin retainer agreement. A third-party beneficiary, they claimed, is someone who may enforce a contract because the contract is made expressly for his or her benefit. The terms of the contract, however, must demonstrate the express intent to confer the benefit. The Court of Appeal concluded that the Lloyd's underwriters were not third-party beneficiaries of the retainer agreement. The retainer agreement describes the scope of legal services to be provided by the Weingarten law firm to the defendants in the MXB action. Nothing in the retainer agreement demonstrated an express intent to benefit a third party, whether Lloyd's underwriters specifically or any other insurance company generally. The complaint did not assert claims against Lloyd's underwriters that are based on the Levin-Weingarten retainer agreement. The claims were based on the insurance policy provided to Weingarten by Lloyd's underwriters. The complaint, therefore, did not rely on or use any terms of the retainer agreement as a foundation for its claims. Accordingly, the Court of Appeals concluded there was no basis in law or equity for preventing Weingarten from suing Lloyd's Underwriters in court, and there was no basis to compel arbitration. The court noted that before referring a dispute to an arbitrator, the court first determines whether a valid arbitration agreement exists. Thus, the trial court properly determined the threshold issue of whether the non-signatory defendants, the Lloyd's Underwriters, could compel the signatory plaintiff, Weingarten, to arbitrate his claims. In my opinion, if the Lloyd's Underwriters wished to arbitrate disputes between themselves and their insureds, it would have been easy to include in the contract of insurance an arbitration agreement like the agreement in the Weingarten retainer agreement. Although the Lloyd's Underwriters provided a defense to the malpractice agreement and lawsuit, they refused a proposed settlement within the policy limits. Weingarten claimed it was harmed because Lloyd's Underwriters failed to accept the settlement agreement, a common claim in a bad faith suit. The attempt to compel arbitration was designed to avoid trial on the bad faith issue, and although creative, it did not have a basis in fact or law that the Court of Appeal was willing to accept. And therefore they will go to trial, or settle, or resolve their disputes in one way or another. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL, zalma.com/blog. You can subscribe to the blog by simply clicking on the subscription button. You can also subscribe to these videos at rumble.com and at youtube.com. And if you have watched this video, please click on the like button if you watched it on YouTube, or the Rumble button if you watched it on rumble.com. And if you found this blog and this video to be of use to you, please tell your friends and colleagues so that they can also subscribe to the blog and the videos. Thank you for your attention, and you might also want to consider subscribing to my Locals community or my Substack publications.